On June 18, 2026, the Supreme Court of the United States issued one of the most significant Second Amendment decisions in years. And I am not using the word significant loosely. In a 9-0 ruling in United States versus Hemani, every single justice agreed that the federal government cannot strip a person of their Second Amendment rights and send them to prison for up to 15 years based solely on the fact that they use marijuana. Not because they were dangerous, not because they were intoxicated while armed, not because they were addicted, just because they smoked marijuana a few times a week. The Supreme Court said unanimously that prosecution under the federal drug user gun ban applied to that person alone violates the Second Amendment. And this ruling has implications that go far beyond one man in Texas. If you own a firearm and you have ever used marijuana, in a legal state or otherwise, you need to understand exactly what this ruling says, what it means for you right now, and critically, what it does not change. Because the gap between the headlines and the actual ruling is enormous, and getting this wrong could cost you your gun rights. Subscribe right now because this decision dropped 48 hours ago, and most gun owners still don't understand it yet. Let me start with the man at the center of this case. Ali Daniel Hemani is an American-Pakistani dual citizen who lives in Texas. The FBI had been investigating him on unrelated matters, specifically concerns about potential ties to foreign organizations. The FBI obtained a search warrant and searched his home. During that search, agents found a Glock 9mm handgun, 60 grams of marijuana, and 4.7 grams of cocaine. Hemani was interviewed. He told the authorities that he used marijuana every other day, regularly, a few times a week. The government did not accuse him of being addicted to marijuana. The government did not claim he was ever dangerous. The government did not allege he had ever been found intoxicated while armed. He was not charged with any terrorism-related offense, any violent crime, or any offense involving misuse of a firearm. He was charged with one thing and one thing only: possessing a firearm while being an unlawful user of a controlled substance in violation of 18 United States Code Section 922 G3, part of the 1968 Gun Control Act. Here is why that charge matters so much. The penalty for a knowing violation of Section 922 G3 is up to 15 years in federal prison. 15 years for using marijuana and keeping a gun in your house. And if convicted, a second consequence kicks in automatically, because a conviction under 922 G3 is a crime punishable by more than a year in prison. It triggers the separate felony firearm prohibition under 18 U.S.C. 922 G1, the felon in possession statute, which means if you are convicted of being a drug user in possession of a firearm, you are permanently barred from owning or possessing any firearm for life. Life. Based on marijuana use. Based on no showing of danger. That is what the federal government was seeking to impose on Ali Hemani. Hemani moved to have the indictment dismissed, arguing that applying Section 922 G3 to him violated the Second Amendment. The United States District Court considered his motion. The case eventually went to the Fifth Circuit Court of Appeals. The Fifth Circuit ruled in Hemani's favor. It held that applying the drug user gun ban to Hemani based solely on his marijuana use violated the Second Amendment. The government then did something that many legal observers called a serious mistake. The government under the Trump administration, with Solicitor General John Sauer arguing the case, appealed the Fifth Circuit's ruling to the Supreme Court. The government fought all the way to the highest court in the land to preserve the right to prosecute a marijuana user for possessing a firearm when there was no showing of actual danger whatsoever. Oral arguments were held on March 2, 2026, and based on the questions from the justices at oral argument, almost everyone watching predicted the government would lose. On June 18, 2026, the court proved those predictions correct, unanimously. If you are finding this important, subscribe right now, because in the next few days I will be doing a deep dive into what Hemani means specifically for gun owners in marijuana legal states, for pending criminal cases, and for the future of the other 922 G prohibitions. Subscribe so you are first to get those breakdowns. Let me explain the legal framework the court applied, because it is the same framework we have been covering on this channel for years. The Bruin test. Under the 2022 Supreme Court decision in New York State Rifle and Pistol Association versus Bruin, any Second Amendment challenge runs in two steps. Step 1. Does the Second Amendment's plain text cover the conduct at issue? Step 2. Is the challenged regulation consistent with the nation's historical tradition of firearm regulation? If the government cannot point to historical tradition that is relevantly similar to the modern restriction, the restriction fails. The government actually conceded step 1 in Hemani. They agreed that Section 922 G3, as they were applying it to Hemani, burdened conduct that the Second Amendment presumptively protects. So the entire case came down to step 2, history. Could the government find a historical analog that justified disarming marijuana users automatically based solely on regular use? The government tried. They pointed to what they called habitual drunkard laws from the founding era and the 19th century. These were real historical laws. They came in 3 general categories. First, vagrancy laws that allowed courts to confine habitual drunkards in workhouses or jails. Second, civil commitment statutes that allowed courts to appoint guardians for habitual drunkards or have them committed to asylums. Third, surety laws under which judicial officers could require habitual drunkards to post bonds for their good behavior. The government argued these laws are relevantly similar to Section 922 G3, both in why they existed, to protect public safety from those impaired by intoxicants, and in how they operated, by restricting the liberties of those who regularly used intoxicants. Under the Rahimi framework for historical analysis, a historical law and a modern restriction must be relevantly similar in the why and the how. The government said their analogy met that test. Justice Gorsuch, writing for 7 justices, systematically dismantled that argument on every metric. The majority opinion rejected the habitual drunkard analogy for 3 independent reasons, and each one standing alone would be enough to sink the government's case. First, on who was targeted. The government argued that historical habitual drunkard laws targeted people who regularly used intoxicants, just as Section 922 G3 targets people who regularly use controlled substances. The court rejected this. Historical habitual drunkards were not simply people who drank regularly or even heavily. A habitual drunkard, at the founding and for decades following it, was someone who drank so excessively and so chronically that they could not conduct their own affairs. They were practically incapacitated. Their drinking rendered them unable to manage their own lives. That is an entirely different category from someone who, as the court put it, uses marijuana a few times a week. Gorsuch was blunt about the gap. He wrote that had habitual drunkard laws applied to those who simply drank regularly, many notable early Americans could have faced trouble. Section 922 G3 doesn't require the government to show you are incapacitated or unable to manage your affairs. It just requires that you use any controlled substance unlawfully with any regularity whatsoever. Second, on why the laws existed. The government argued that both historical drunkard laws and Section 922 G3 exist to protect the public from dangerous persons. The court rejected this framing too. Historical drunkard laws, the court found, targeted those who were practically incapacitated and therefore genuinely unable to act responsibly in society, including while armed. The laws addressed real, demonstrated incapacity. Section 922 G3, as the government was applying it, targets people without any showing that their drug use has ever made them dangerous. The government specifically did not claim Hemani was dangerous, did not claim his marijuana use impaired him while armed, did not claim he was incapable of acting responsibly. The why of the historical laws and the why of the modern prosecution simply do not match. Third, on how the laws operated. This is perhaps the most important distinction for the broader implications of this decision. Historical habitual drunkard laws involved individualized legal proceedings. A court had to make a specific finding about a specific person before their liberty was restricted. Whether it was a vagrancy proceeding, a civil commitment hearing, or a surety proceeding, there was a legal determination. Someone in a position of authority had to look at an individual and make a finding about that individual. Section 922 G3, as the government argued it applies, is automatic. The moment you become an unlawful user of any controlled substance, your gun rights vanish, immediately, with no hearing, no finding of dangerousness, no individualized assessment of any kind. As the government framed it, it doesn't matter what substance you use, in what amounts, whether it has ever made you dangerous, why you keep a gun, or how safely you store it. Automatic disarmament. The court found this automatic categorical approach has no adequate historical analog. Taken together, the court concluded, the government's analogy fails on every metric. The habitual drunkard laws targeted different kinds of people for different reasons, operating through fundamentally different mechanisms. As Justice Gorsuch summarized, the government asks us to analogize all such persons to habitual drunkards. To state the analogy is to expose its deficiency. The prosecution of Hemani under Section 922 G3 is inconsistent with the Second Amendment. Quick legal note. This is educational information, not legal advice. This is one of the most important gun rights decisions in years, and the implications for your specific situation depend heavily on the facts of your circumstances and the laws of your state. Always consult with a qualified attorney. Now, let me explain the breakdown of justices. The 9-0 vote is a little misleading about how unified the court actually was. 7 justices joined Justice Gorsuch's full majority opinion: Chief Justice Roberts, Justice Thomas, Justice Sotomayor, Justice Kavanaugh, Justice Barrett, and Justice Jackson. 2 justices reached the same outcome but through a separate concurrence rather than joining the majority opinion. Justice Alito, joined by Justice Kagan, wrote separately. Alito and Kagan agreed the government lost, but they would have ruled on even narrower grounds. Alito's concurrence said that the analogy between historical habitual drunkard laws and modern marijuana use is simply too far afield. We need not say more to decide this case, he wrote. And I would for that reason say no more. In other words, Alito and Kagan did not sign on to the majority's broader reasoning about individualized dangerousness determinations and historical process requirements. They just said these particular analogs don't work, and left it there. Justice Thomas filed a separate concurrence agreeing with the majority, but going even further. Thomas urged his colleagues to reconsider a broad swath of federal gun restrictions beyond the one at issue in this case. Thomas has long argued that many federal gun laws lack adequate constitutional grounding. His Hemani concurrence signals that he sees this decision as a springboard for future challenges to other provisions of the Gun Control Act. Hey, 73% of people watching right now are not subscribed. A 9-0 Supreme Court decision on your right to own a firearm just dropped 2 days ago, and more decisions are coming before the end of this term. Subscribe right now so you never miss a development that could affect your rights. Now, let me address the Hunter-Biden connection, because it is impossible to discuss Hemani without mentioning it. The same statute, Section 922 G3, was at the heart of the prosecution of Hunter Biden, the president's son. Hunter Biden was charged with illegally purchasing a firearm while being addicted to crack cocaine. He was convicted by a jury in Delaware and then pardoned by President Biden before sentencing. The government successfully prosecuted Hunter Biden under 922 G3. Does Hemani undermine that conviction? The short answer is complicated. The critical distinction between Hemani and Hunter Biden is what the government claimed. In Hunter Biden's case, the government alleged and proved that he was addicted to crack cocaine, not merely a regular user. The government argued he was someone whose drug use rendered him practically incapacitated and unable to responsibly possess a firearm. The court's reasoning in Hemani explicitly leaves open whether the statute can constitutionally be applied to someone who is a genuine addict, someone whose drug use has incapacitated them. Hemani's case was specifically about someone who was not alleged to be addicted, not alleged to be dangerous, not alleged to be impaired while armed, just a regular user. So the Biden case and the Hemani case sit at different points on the spectrum. But Biden was pardoned anyway, making the question largely academic in that specific case. Now let me address the most important practical question every gun owner in America is asking right now. What does Hemani actually mean for me? Here is where I need you to pay very close attention, because the gap between the headlines and the reality is substantial. The Hemani ruling is what lawyers call an as-applied challenge. Hemani did not challenge Section 922 G3 on its face. He did not argue that the statute is unconstitutional in every possible application. He argued that it is unconstitutional as applied to him, a person who uses marijuana regularly but is not a drug addict, not dangerous, and not intoxicated while armed. The Supreme Court agreed with that narrower argument. The majority opinion explicitly describes its ruling as narrow. The statute itself, 18 U.S.C. 922 G3, is still on the books. It is not struck down entirely. The DOJ can still prosecute people under it in appropriate circumstances. What Hemani establishes is that regular marijuana use alone, without more, is not enough to justify prosecution under this statute consistent with the Second Amendment. The government needs something more. What that something more is will be determined in future cases. The court did not define exactly what additional showing would be sufficient. This is actually an important limitation of the ruling. Let me be specific about what Hemani does and does not change. What it changes. If you are a regular marijuana user who has never been found dangerous, never been intoxicated while armed, and are not a genuine addict, you have a strong constitutional argument against prosecution under Section 922, G3, based solely on your marijuana use. Courts in the future will have to apply Hemani's reasoning in cases involving prosecutions of marijuana users. Many pending prosecutions under 922, G3, involving mere regular use may be dismissed. Some convictions may be challenged on appeal. The broad automatic application of 922, G3, to everyone who has ever used any controlled substance with any regularity is constitutionally suspect after Hemani. What Hemani does not change. It does not change the federal background check form, ATF Form 4473. That form still contains question 21E, which asks if you are an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance. If you answer yes, you are still disqualified from purchasing a firearm from a licensed dealer. Hemani addressed prosecution for possession based solely on regular use. It did not directly address the 4473 question or the purchase prohibition. These are related but distinct legal questions. If you live in a state where marijuana is legal under state law, you may have been tempted to think that Hemani gives you the green light to legally purchase firearms while using cannabis. It does not. Marijuana remains a Schedule I controlled substance under federal law, regardless of state legalization. The tension between state marijuana laws and federal gun law was not resolved by Hemani. Hemani also does not protect someone who is armed while actively intoxicated. If you are high with a firearm in a state where carrying is legal, that combination creates a different legal exposure that Hemani does not address, and Hemani does not address genuine addiction. If you are someone whose drug use has rendered you incapacitated, unable to manage your affairs, or genuinely dangerous, the court's reasoning suggests the government might still be able to apply 922 G3 to you with adequate historical support. The court specifically left that question open. Let me also talk about the broader implications of Hemani's reasoning for other areas of gun law, because what Gorsuch wrote about individualized dangerousness determinations matters far beyond marijuana. The majority opinion places enormous weight on the absence of individualized proceedings in Section 922 G3's operation. The historical habitual drunkard laws, the court noted, worked through legal proceedings where someone in authority made a specific determination about a specific individual. Modern automatic categorical disarmament, without any individualized hearing, lacks that historical grounding. This reasoning has been noticed by Second Amendment scholars and attorneys for its potential implications in other contexts. Red flag laws, for example. Extreme risk protection orders remove firearms from people before any finding that they have actually done anything dangerous. Some red flag laws allow emergency orders with minimal process. The Hemani majority's emphasis on pre-deprivation hearings and individualized determinations could be cited in future challenges to red flag laws that operate with insufficient process. Justice Thomas's separate concurrence went even further, inviting challenges to other 922G provisions. There are multiple prohibited person categories under federal law, including felons, domestic violence misdemeanors, and others. Thomas's concurrence signals he is open to reconsidering whether all of those categories are constitutionally sound under Bruin. This is not the last case we will see challenging provisions of the Gun Control Act. Let me also address the unusual political coalition that formed around Hemani. Civil liberties organizations, including the American Civil Liberties Union, supported Hemani's position. The NRA also backed Hemani. The ACLU and the NRA do not agree on very many things, but they agreed on this. The ACLU's legal director, Cecilia Wang, said after the ruling that the unanimous 9-0 decision makes it clear that the government cannot treat marijuana use alone as grounds to strip people of their constitutional right to own a gun. She added that the ruling sends a strong message that officials may not criminalize large groups based on broad assumptions about danger, and that such categorical restrictions risk being unfounded. Gun control organizations were on the other side, supporting the government's position. Unusual alignments in Supreme Court cases often signal that the issue cuts across traditional political lines. Hemani absolutely does. Both gun rights advocates and civil libertarians recognize that automatic categorical disarmament based on status rather than conduct or individualized dangerousness is constitutionally problematic. Let me also address the Trump administration's role in this case. The Trump administration defended the prosecution of Ali Hemani all the way to the Supreme Court. Solicitor General John Sauer argued the government's position. This is the same administration that has been suing states over assault weapon bans, filing amicus briefs against Illinois' PICA, and taking aggressive pro-gun positions in other litigation. Yet on this case, the administration defended a restriction that sent a gun rights advocate to the Supreme Court. And the administration lost. Unanimously. This illustrates something important about how gun rights law actually works. The constitutional analysis does not follow political loyalties. The text and history drive the analysis. And when the analysis is applied honestly, it produces results that do not always align with the political preferences of the administration in power. Now let me give you practical guidance on what you should do right now based on the Hemani ruling. First, if you have been charged with or convicted of a violation of Section 922, G3, based on marijuana use alone, contact a criminal defense attorney immediately. Hemani may provide you with strong grounds to dismiss charges or challenge a conviction on appeal. The sooner you act, the more options you may have. Second, if you are a marijuana user who also owns firearms, understand that Hemani does not give you clear legal protection in all circumstances. Do not interpret this ruling as permission to ignore the 4473 form or to purchase new firearms while answering the drug use question dishonestly. The legal landscape around marijuana and firearms is still evolving, and you need state-specific legal advice. Third, if you live in a state where marijuana is legal and you are a gun owner, know that the federal-state conflict in this area is still very much unresolved. Hemani is a step toward more protection for marijuana users, but it is not a complete solution to the federal-state legal conflict. Fourth, understand what Hemani requires for a prosecution to proceed going forward. The government will need more than just evidence of regular marijuana use. They will likely need to show something more individualized, something connecting the drug use to actual dangerousness or to circumstances that have historical support. Regular use alone is not enough. Fifth, watch for future cases. Hemani is not the final word on 922, G3. It is an as-applied ruling. The lower courts will now have to work out exactly what the government must show to validly prosecute under this statute. Those cases will be litigated, and the Supreme Court may eventually need to provide more guidance. Sixth, do not spread misinformation about this ruling. The headlines saying gun rights for marijuana users are now protected are misleading. The ruling is narrow. It protects against prosecution based solely on regular use when there is no showing of danger. It does not broadly protect all marijuana users in all circumstances involving firearms. Let me address what is still coming from the Supreme Court before the term ends, because Hemani is not the only significant ruling we are waiting for. The court is expected to decide Woolford versus Lopez before the end of June 2026. That case addresses when and where people with concealed carry permits can possess firearms in publicly accessible private locations like most businesses. The question is whether a permit holder can enter a private business without informing the owner they are carrying unless specifically asked to leave. That decision could dramatically affect how concealed carry works in practice across the country and is expected within days. The court is also still relisting Viramontes versus Cook County, the case challenging Illinois' ban on so-called assault weapons in Cook County. Every relist raises the question of whether the court is about to grant or deny review of that case. With the Seventh Circuit still sitting on its ruling in the consolidated PICA cases, the Supreme Court may decide to wait for that circuit court ruling before weighing in on the assault weapons question nationally. And Virginia's new assault weapons ban, which Governor Spanberger signed just weeks ago, is already being challenged in multiple federal and state courts. The Fourth Circuit will eventually have to grapple with that law under the Bruin framework, and whatever happens there may contribute to the circuit split that finally brings the assault weapons ban question to the Supreme Court for resolution. In the meantime, Hemani stands as the most recent and most significant gun rights win from the court, a unanimous ruling that the government cannot automatically strip Second Amendment rights based on marijuana use alone without individualized evidence of dangerousness, without a meaningful legal process, and without an adequate historical foundation. That principle, stated unanimously by all 9 justices, is now the law of the land, and it will echo through Second Amendment litigation for years. Subscribe right now so you are the first to know when Wolford drops, when the Seventh Circuit issues its pica ruling, and when the Supreme Court takes its next major step in defining the scope of your Second Amendment rights. This is a historic moment in gun rights law. The decisions are coming fast and you need to stay informed. And please remember, this is educational content only. It is not legal advice. For your specific situation, always consult with a qualified attorney who knows the gun laws in your jurisdiction. This is the law that protects your rights. Know it, understand it, and stay informed about how it develops.